Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration, and today we are wrapping up our series on the H-1B visa classification, at least for now. This video is about the employer's responsibilities, and the very first responsibility is the employer must pay a certain wage to the H-1B employee. That is the prevailing wage or the actual wage, whichever is higher. The prevailing wage is the wage set by the Department of Labor. That's based on the geographical area, the standard occupational code, and there are 4 wage levels within each standard occupational code and geographical area. Wage level 1 is for entry-level employees. Wage level 4 is for senior-most employees. The actual wage is the wage that the employer pays to similarly situated employees. So employees working in the same geographical area and the same or similar occupation and with the same or similar education and experience levels. The employer attests on the labor condition application or LCA that they will pay whichever is higher, the prevailing wage or the actual wage, and they specify the amount that they're going to pay to meet that requirement. The LCA or labor condition application is something that we prepare on behalf of the employer based on information that they provide and submit to the Department of Labor online. The Department of Labor takes about 7 days, about a week, to certify it, and we have to include that certified LCA with the H-1B petition when we file it with USCIS. So the LCA and the attestation of the wage that the employer is going to pay is an integral part of the H-1B filing. Second, the employer has to provide the same working conditions and benefits that they give to U.S. workers. If there's a material change in the terms or conditions of employment, the employer has to notify USCIS, and that's done through an amended petition with USCIS. We have a previous video all about that process. The H-1B employer cannot bench an H-1B employee. That means that if there is not work available for the H-1B employee to do, the employer cannot just not pay the employee. That means that there can't be unpaid furlough. The employer has to continue to pay the wage that they attested to on the LCA throughout the employment period. If the employment ends because the employee leaves or because the employee is terminated, the employer has to notify USCIS that the employment has ended and withdraw the LCA that was filed with the Department of Labor unless multiple positions were listed on the LCA. The employer has to maintain certain documentation, namely the public access file. That is a set of documentation required by the regulations. Our office prepares the public access file in relation to each H-1B petition that we prepare, and we give specific instructions to the employer on how to maintain that on an ongoing basis. And of course, we're here to answer questions as well. If the H-1B employment ends through termination, in other words, if the employer terminates the H-1B employee for performance reasons or because of a layoff before the end of the current H-1B status, in other words, before the current H-1B petition ends, the employer has to offer the reasonable cost of return transportation home to their last country of residence. And then the employer has to be open to possible site visits from government officials. It's possible to receive a site visit from an FDNS officer, which is a fraud detection officer. In that case, the officer likely will ask information. It's usually straightforward information to confirm that the information submitted in the H-1B petition is actually true. It is also possible to receive a site visit or a visit from a Department of Labor officer. They may be initiating a Department of Labor audit. If either of those happen, if you receive a site visit from an FDNS officer or definitely from a Department of Labor officer, you will definitely want to contact your immigration attorney or a qualified immigration attorney before speaking with them, just to make sure that everything is aligned and in place. And then finally, the employee in general, and this is a bit complicated, but the employee in general is prohibited from paying the legal fees or filing fees associated with the H-1B petition. This is, like I said, a bit complicated, but it's related to the prevailing wage. The prevailing wage, or an employee cannot pay the legal fees or filing fees and then bring by virtue of doing that, bring their salary below the prevailing wage or actual wage, whichever is required. In addition, there are certain USCIS filing fees that have to be paid by the employer no matter what. This may seem like a big set of responsibilities and obligations, and it is, but it's also an honor to do so, and it's absolutely worth it to hire and to retain this amazing foreign national talent, and we are here to answer questions every step of the way. Our next video will be on the exciting topic of premium processing, which applies to the H-1B classification, but to other classifications as well. I hope that you found this information helpful. Please make sure that you have subscribed to our YouTube channel if you have not already, so that you'll be notified of our next videos. And until next time, my name is Emily Sumner.